When you're a small business owner, you need access to the tools and support you never knew you needed. At the Dream Center, we offer co-working space and support services that elevate the everyday entrepreneur. Centrally located in the rising Soul City corridor of Chicago, we're the ideal environment, offering monthly and quarterly networking for members. Bring your idea to fruition. Expand to new heights. Call now or visit thedreamcenter.co today.
Let me try that again. Good evening, and welcome to the Dream It Out Loud podcast webinar series. My name is Marcel Action Jackson, and I am the CEO of the Dream Center Co-working and Business Support Services. I am so happy to have you all join us. We shall be getting started shortly. Listen, tonight is very exciting. It's our first live webinar. It's not a podcast. It's not an interview. We've invited a professional, top in her industry, to share with us, to educate us, and to teach us. And so this would normally only be offered to Dream Center members. And thank you, Jacqueline Malone. Make sure you're dropping in the comments. Say hello. Say hello. We want you to be very engaged. So the reason we offered this, and it's open to the public, if you're tuned in via the webinar link, we also are streaming live on Facebook and YouTube. And so if you're on Facebook or YouTube, you can share this link with family or friends. The reason that we're doing this openly is because when God gave me the vision to launch a business reset challenge, I was rushing and trying to get it going. And I thought it was going to be a 30-day challenge, and I was trying to rush. But in order to make sure that we had quality speakers, quality materials, quality templates, I decided to pray. I was going to push it back to October, but then in prayer time, the Lord gave it to me that I didn't need 30 days. We needed 21 days. And statistics have shown that habits can be created in 21 days. So for those of you that don't know, we'll share more at the end, but the Business Reset Challenge is for entrepreneurs or aspiring entrepreneurs to make sure that you have your foundation set correctly. I've been in business for 21 years, and one of the number one things that I've seen in my travels is that African-American businesses, minority businesses, are not prepared for a lot of opportunities because they don't have the right foundation. They don't have their companies incorporated or incorporated the right way. They don't have EIN numbers. They're commingling funds. They don't have business bank accounts. They don't have online real estate, which, of course, is your website. And, so what we wanted to do here at the Dream Center, and shout out to Brother Tony Tidwell that just tuned in. I was meeting with him earlier. And one of the things that I know that's about to happen there is about to be a shift taking place for entrepreneurs. There are opportunities that are coming down the pipeline. And in order to, the old saying, if you stay ready, you don't have to get ready. So we want to make sure that you're ready for these opportunities. And our vice president announced yesterday, if elected, she is working on making sure, and I'm just going to talk about one initiative. She says that her goal is that 1 out of 3 federal contract goes to a minority business. So what does that mean for us? The opportunity is if there is a contract opportunity available for your business, but your business is not set up right, guess what? You won't be able to get that opportunity. People say, hey, I want grants, but you can't get a grant because when we're filling out the grant application, you don't have your taxes done. Your business isn't incorporated. You haven't been in business for 2 years. You don't have business credit. We've been working with banks and lenders talking about access to capital, but we can't access the capital not because of just systemic racism, but because we don't have the right credit scores. We don't have business banking. We can't show the proper paperwork that's needed. So that's why we created the 21-day Dream Builders Business Reset Challenge. And it is kicking off Monday. In this 21 days, we will not get everything done, but I promise you, we'll be holding your hand. You'll be working with myself and my team, where every day for 21 days, you'll be receiving tools, resources, education And every Thursday, we will have a guest speaker that's speaking. And our lineup, of course, kicks off tonight because in business, you need two things. And sometimes we can't afford them right out back, but you need a lawyer and you need an accountant. And if you have those two things, I promise you, your business will be smooth sailing. But we wanted to bring you these resources. So this week we have Attorney India Rios. Next week we have Stephen and Essence Keys that are accountants that will be talking and educating us on business taxes. The following week we'll be doing marketing with Kiana Barber, the CEO of WDB Marketing, who is killing the game when it comes to marketing and branding. And then we're going to close the challenge off with Mikai Brown, Vice President of U.S. Bank, Access to Capital Advisor. And if you don't know, U.S. Bank has released a couple of $1 million earmarked specifically for Black businesses. And her job is to make sure that she's funding Black businesses, especially in the Chicagoland area. And I was blessed on last week to be invited on tour with 40 plus U.S. Bank executives to talk about the Dream Center, the Dream Builders, and all that we have going on. So if you have not signed up yet, make sure you sign up for this 21-day challenge. It's going to be off the chain. And the goal is, this is the last month of the third quarter. We want to prepare to have a phenomenal fourth quarter, because if you finish strong, it's easier to start stronger. And so we're preparing for 2025. I wish I had like some help, somebody to say amen or something. I'm no preacher, but if somebody said amen, they may give an offering. But shout out to everybody tuned in so much so far. We got Jacqueline, Denise, Tony, Aaron, Allison. What's going on? And Allison is going to be doing a workshop with us. Quick shout out. Allison has gotten over, I may be saying a low number, but over $30 million in grant funding. Let's say that. And so thank you. I got an amen over there. Thank you, Jacqueline. Thank you, Aaron. Allison has gotten over $30 million in grants. But here's the thing. You have to, be compliant to receive grant funding, capital from banks. But then we have to teach you how to stay in compliance. Because at the end of the money, you got reports to fill out. But we're going to go through all of that. But the first thing is to get your foundation set up properly. We must make sure that everything you need to go into the room, you have it. And it was just announced today, and this is it for my speech because I'm going to move out of the way. I wanted at 6:10 to get this going. So we're on time. But today, the mayor announced, and let me make sure I'm saying it right, that they have open bids. It's hot off the presses for 112 new concessions in Terminal 1 and Terminal 3 at O'Hare Airport. So if you're a business owner and you have a brick and mortar, being in an airport is like an ATM machine. Trust me, it's going to be printing the capital. So at this time, without further ado, I want to introduce our guest presenter for the evening. That's none other than my attorney, Attorney India Rios. She's the owner of the 7-Eleven Law Group. She has a passion for helping the community, especially entrepreneurs. Her signature is trademarks and making sure that you protect your brand. But she is a business attorney through and through. I'll let her tell you about some of her testimonies, but acquiring businesses is a thing. You can purchase a business, but you need a business attorney on your side. And she was able to negotiate one of probably the biggest deals in our community for an entrepreneur to open a second location. So without further ado, I unmute myself. I would like, without further ado, to welcome Miss Attorney India Rios.
Hi, everybody. I'm so happy to be here with you all today. Thank you so much, Marcel, and to the Dream Center for having me. We're going to have a great session.
Well, listen, what we're going to do, I'm going to move out of the way. We got people coming on in. I'm going to allow India to present this great presentation. But what I want you to do, you're tuned in, I want you to drop questions in the comment box, because at the end of the presentation, I'm going to come back and help, well, I'm sure she can read them, but if she missed any, read the questions to her so that, and hey, listen, I just got to say, this is the only time you're going to be able to ask some free questions. You're going to have to pay for a consultation after this. So listen, learn, get your questions ready, and we're going to have a good time. So Attorney Rios, I'm going to let you take it away.
Okay, well, thank you so much. So as Marcel mentioned, I am primarily a trademark attorney, but I do a ton of business law work as well. Trademarks is just my passion, but business in general is truly my passion, and helping you protect and own your business and your brand. So I'm not going to waste any time, but I do want you guys to know, feel free to drop questions in the chat as we're going, because I'll try and answer your questions while we're on the slide, while I'm talking about the subject, if you have a question. And I'm not going to try and keep you guys here for too long, but definitely, if you have a question, please feel free to ask it. So, legal gems for entrepreneurs. Let's move on. The first thing that I always tell people is that a lot of times you really need to develop that entrepreneurial mindset, right? And what I mean by this is, you may be already running a business, but you're running it like a hustle. You're running it like a side business or like a hustle, and you really haven't formalized the things that you need to create protection for yourself, for your business assets, and for your personal assets. So just briefly, an overview of some things that you want to think about when you're developing an entrepreneurial mindset are: one, what are the characteristics of that? What are the benefits, and how are we going to cultivate it? Right? I think that the key characteristics are listed here on the screen: resilience, vision, adaptability, and initiative, right? And I feel like most entrepreneurs already have some form of this internally, and that's how you got started in the first place, right? The benefits of having these thought processes or thinking of this way, thinking about being an entrepreneur, is you'll start to develop, problem solving skills and innovation. And you'll also start to recognize opportunities for your brand to grow, opportunities for your business to grow, opportunities for you to connect with other businesses and, engage on a higher level. How to cultivate these things: by continuously learning, by thinking about your risks, doing, risk benefit analysis for any deal that you're entering into, any conversations that you're having about your business, and really just putting yourself in a position to where you're thinking about the things that you're doing from the position of, how would a CEO approach this, right? When you're thinking about risk management, continuous learning. And no matter what sector of business you're in, it's evolving every day. You should be up to date on your business, what the norms are in your industry, what industry standards are for your business, so that you can always make sure you're abreast with whatever regulations are going on. And then a lot of people, nobody likes to talk about their failures, but I would encourage you to embrace your failures, right? To learn from the mistakes that you've made in business. And people make mistakes all of the time. Even me, as an early on business owner and learning things, sometimes we make mistakes. But the most important thing when you make a mistake is to really recognize and to reflect on it and think about it and ask yourself, how could I have positioned myself or my business in a way that we wouldn't have been affected by this? Or post failure, how can I position myself and my business in a way to where we bounce back from this and never make this mistake again, right? Next thing, the first thing that we're going to talk about is like the importance of business structures, right? So before I even get into the slide that kind of like starts breaking down the types of business structures, let's just go ahead and talk about, what do I mean by business structure? Are you a sole proprietorship? Are you an LLC? Are you a corporation? If you are a corporation, what type of corporation are you when it comes to your tax classification? There's a difference between how you're registered and what your business entity or your classification is and your tax classification. And you always want to keep that in mind, that these things aren't the same, right? So the importance of business structure is, choosing the right one. What should you consider? Let's get into some overviews. What is a sole proprietorship, right? A sole proprietorship is a business where there's no distinction between the business itself and the owner, right? This type of entity doesn't require any form of registration with like the Secretary of State or anything of that nature. But I'll tell you that this is the least recommended type of structure to organize. This type of structure is really good for somebody who has really low risk, really low chances of finding any liability or being sued for anything. And a lot of times, in most cases, nobody is really situated where they're just absolved from personal liability. And when you're in a sole proprietorship, you don't have a corporate shield, right? And a corporate shield is what protects your business's assets from your, like, creates a barrier between your business assets and your personal assets, right? You want to have a corporate shield. You want to know that, God forbid, if a judgment is entered against your business for $1 million, that $1 million judgment isn't going to attach to your personal property, to your house, to your car, to your social security number, to where your wages could be garnished by others, right? You're going to want to make sure that you're in a situation where you don't have that. So a sole proprietorship is probably my least recommended type of entity for anybody to enter into, regardless of what type of business you're in. But if you're going to be a sole proprietorship, and a lot of you, if you're operating a business right now with no LLC or any form of registration, then by default, you're running a sole proprietorship. That's just like the default standard. And it's not necessarily in your best interest. Some things about the sole proprietorship is, it's easy to form because it takes no formation at all, right? You have full control because you're the only person that's involved in this business. This is a one-person operation anytime that you have a sole proprietorship. And then the taxes are simple, but they're really simple because you're just being taxed as an individual. You're not doing a separate set of taxes for your business, and you don't have any reason or grounds to because you haven't registered anything. So in this situation, and again, the more important thing here is the disadvantages. Unlimited personal liability. That is what you're looking at when you're a sole proprietorship. You have unlimited personal liability. And then also limited growth potential. Just because in that structure, you won't have a business bank account because you don't have any documents to create a business bank account. You won't have any access to business financing or any types of loans or potentially even grants that are geared towards companies even that are in your industry because you haven't registered or done the work to be able to have access to those things. A partnership, right? A partnership is two or more people that are involved in some type of business activity for the purpose of making money. Partnerships are good for small businesses with one or two more owners that want to share responsibility. The one thing to be mindful of with partnerships is that once you've registered or you've become a partnership, you also have to consider being taxed as a partnership, right? There are things that you can do in paperwork that you could do with the IRS so that you can have like a pass-through taxable income. But another thing that you have to consider here, so you'll only pay taxes one time. You'll probably pay a little bit of a higher tax amount if you are in a partnership and you haven't done anything to reclassify how you're taxed. And that's one thing that you always want to consider, right? Is that, again, business entity organization and tax classification are not the same. There's a space in between them, right? Because you could be registered as a partnership, but taxed as a corporation if you do the necessary paperwork. So that's just something that you want to keep in mind, is that how you've organized is not necessarily how you have to be taxed. And that in a partnership, the funds and all of those gains are going to pass through to each partner as an individual when they're doing their individual tax paperwork at the end of the year. Partnership types. There are general partnerships and there are limited partnerships. General partnerships, all of the partners sharing equal liability. In a limited partnership, one general partner must manage the business with personal liability. And then the other members of that partnership will have limited liability, but they typically wouldn't have management control. I feel like if there are 3 to 5 people at a bare minimum in your business, this probably isn't a good model for you, right? Unless one person is willing to take on all of this personal liability. And I'm not sure why anybody would necessarily want to do that. There could be some times where there could be benefits to being structured this way, but then also you just have to keep in mind that whoever that person is that takes on the most liability generally will have the most power and will have the most say over how the business is run. And that's generally how the partnership agreement will be written, in a way to structure that, because they have taken on significantly more risk than the rest of the partners. Partnership advantages: shared control, simple setup, shared liability in some ways, and then there is room for potential conflicts. When you're in a partnership, you could find that the person that's managing the partnership wants to go in a different route than the people who are just members of the partnership, right? And that could be for a number of reasons. And mainly the primary reason that they might want to, go in a different direction on different decisions is because they solely are going to be personally liable for anything that comes out of this. So that's just something to consider as well. Limited liability company. These are the most common, pretty easy to set up. You don't have to worry about what the liability levels and things like that are going to look like you would with the partnership. And the primary reason that you don't have to concern yourself with what the liability levels would look like you would with the partnership is because you are going to create and solidify that corporate shield, as we formerly discussed. And as we formerly discussed, the corporate shield, right? And what is your corporate shield? To have a corporate shield, you need to have registered a business entity. So a limited liability company is a great way to go with the LLC. You need a business bank account, and you need a tax ID number. You need these 3 things as the initial foundation for a limited liability company to provide you with the corporate shield. To make sure that your corporate shield is solid and you've really solidified that barrier between your business assets and your personal assets, you're going to want to make sure that you're using a separate business bank account for all of your business banking and proceeds. And you're going to want to make sure that in addition to using a separate business bank account for all of your business proceeds and banking activities and things of that nature, that you're also using your EIN when you're signing up for the bank account, when you're signing up for debt, or you're taking out a loan in the business name, things of that nature. Because you want to make sure that you're not providing a personal guarantee. Even when you say, for example, want to take out a lease on a brick and mortar establishment, or you enter into a contract for a business that you're going to be running, you want that contract to be in the business's name, not in your personal name, right? So limited liability companies are really flexible. They could be member managed, or the members could elect to have a manager manage the entity. It's totally up to you guys which direction that you go in. A lot of times it's just really dependent upon how much activity the business is involved in, how many outside contacts the business has. And then there's opportunities for you in a situation like this where there are multiple owners, where you could set parameters on what a person is allowed to do as an individual or independently for a business, and then also set parameters for what they're not allowed to do. So something that you'll see common in a limited liability company is that you can't take out a loan in the business name without majority consent, or you can't enter into any contracts that create extreme business debt beyond X amount of dollars without majority consent. So things like that are easily implemented in this space, to where one person could be managing it, but the members could still have control over how they manage it per se. Here we go again with this chart, and I'll make sure that this PowerPoint is available to you all after this. I'm sure that Marcel has somewhere that he's storing all of these things. But the limited liability company, here we go with the advantages and disadvantages. One of the biggest disadvantages with the LLC is that you find that you're responsible for self-employment taxes, right? So you're paying the taxes that you would normally pay if you were like working at a company or a corporation somewhere, but then you're also paying the taxes or the portion of taxes that employers generally pay on your behalf, right? So there's like a hidden cost of an employee. A lot of times people don't know about it or don't talk about it, but you pay a certain percentage of your taxes, but then at the same time, the company that you're working for will also pay a certain percent of the taxes as well. Next, corporation, very popular. And then as we previously mentioned, the corporation itself is a business organization type, right? Whether a corporation is a C or a S corp. Sorry, I have my phone. Oh my goodness. I have my phone on Do Not Disturb. I hate when people call me multiple times. Anyways, sorry about that. So with the corporations, there's the C corporation and then there's the S corporation, and those are tax classifications, right? So in the standard corporation, the business is taxed separately from its owners. But then in a situation like that, where the business is taxed separately from its owners, you could find yourself paying double tax, right? Because you could be paying tax as an owner of the business or a shareholder of the business, but then also paying tax as an individual for the proceeds that you receive through like payroll, right? So if you're getting dividends from shares and you're on payroll, you could be taxed 2 times. If you do the S Corp designation, that allows all of the profits and losses to pass through the owner's personal tax, and you can avoid double taxation that way. To obtain a S Corp tax classification, all you really need to do is send in a form to the IRS, and they will elect that for you. And then you just make sure that when you file your taxes, you file them as such. Corporations, best for businesses looking to scale, looking to attract investors or potentially go public, such as tech startups, manufacturing companies, or large enterprises, any place where you think that you want to go public and have shareholders and, you know, break the company down into stocks or units of some variety, then you could find yourself in a situation where being set up as a corporation could be in your best interest. Advantages of corporation: limited liability, able to raise capital, they exist forever until you dissolve them. Disadvantages: the paperwork that goes with owning and running a corporation can be time consuming. You're supposed to keep meeting minutes. You're supposed to have a vote and a standard operating procedure for how you run these meetings and how meetings are called and how shareholders vote. It's a lot that goes into actually managing the paperwork behind the scenes on the corporation side. So that's just something to consider. While there are benefits when it comes to potentially being able to avoid double taxation, depending on if you go with the S or the C Corp, and there are benefits when it comes to raising capital and funds, and you do still get to create that corporate shield and minimize your liability, something that you do have to still consider is the fact that you have to do a lot of paperwork to keep that up. So that's just something to consider when you're deciding how you want to do it. The paperwork doesn't have to be as complex, but you definitely are going to need at least a good bundle of the initial documents that allow for this, right? So that you can maintain the proper records that you need to be able to justify any decisions that have been made and to show that all of the shareholders had knowledge of these decisions, all of the controlling and majority shareholders got the opportunity to vote on these decisions, what was raised in meeting minutes, how was it raised, who are the authorized signatories, things of that nature need to be established, and they need to be established in writing, and they need to be established at the outset of creating such an entity, or they should be established at the outset of creating such an entity. And if you haven't established them at the outset, you're gonna establish them eventually, because when it's time for you to file your annual report with the Secretary of State, you're gonna have to provide this documentation. Nonprofit, because I know that we got some lovers in the room, I'm sure, and people who like to establish businesses to help others and to, you know, support different initiatives. Some of the benefits of the not-for-profit are just, that they could be tax exempt. You have to file for tax exemption though. So just because you register a not-for-profit, that doesn't mean that you're automatically tax exempt. You have to file separate documentation to establish your tax exemption. There are different forms and types of tax exemption that you can be looking for, but you're gonna have to file for any type that it is that you want through the IRS. You can be tax exempt for the state, but just because you're tax exempt with your state, that doesn't guarantee or automatically give you tax exemption with the IRS. So those are two separate bodies that you need to work with to ensure that you have your tax exemption. Big things about the not-for-profit that come to disadvantages, they are strictly regulated, right? You can't own or run a not-for-profit as an individual. You have to have a board, at least 3 people. At least here in the state of Illinois, at least 3 people have to be on your board to allow and vote on decisions in regards to any of the not-for-profit's operations. And then that, of course, then creates limited control because you are subject to the regulations for like charitable contributions and campaign funding and fundraising and things of that nature. So you want to keep that in mind. A not-for-profit is great for an entity that has a single, simple, driven mission of like, we want to give scholarships to kids. We want to help communities that are in poverty with food or this, that, and the third. Those direct, on target missions. A not-for-profit is great for something like that, especially, but then you also want to make sure that while it's great for something like that, that you have a board of directors that understands what the goal is, what exactly is supposed to be happening here, and that they're on board with the mission too, right? Because you don't want to have some people that are supporting the mission and understand that we have a one-track focus, while you have another group of people that's like, yeah, I understand that we're a not-for-profit and this is our main focus, but we can make money in this way, that way, or the third. Not-for-profits are allowed to make money. So don't be mistaken by that. You are allowed to fundraise. You are allowed to do campaign things so that you can bring in money. But how you spend that money and what you spend the money on and how it's distributed, all of that is subject to strict regulations. When it comes to paying yourself a salary as a member of a not-for-profit, you can pay yourself a salary, but it must be reasonable. It must be commensurate with the market rate, okay? Marcel popping in. Hope everybody's enjoying this. I hope you guys are enjoying it too. And just to go through something, tax exemption, tax to meet IRS requirements, strict compliance, profit restrictions, and that's the thing. A lot of times with the profits that you bring in, they're supposed to be reinvested into the organization's mission. And the reason that these are so heavily restricted like they are is because, a lot of times with churches and things of that nature, you're collecting these donations, you're collecting money from the people with this message of goodwill. So when you're collecting this money with this message about goodwill and things of that nature, you want to make sure, and the state wants to make sure that you're not taking advantage of people, that you're not collecting money with the thought of goodwill or with the front-facing, facade that you're going to be doing all these great things in the community, but then you're really just self-serving and buying things for yourself. And that's another part of the reason that there's at least a board of 3 requirement, and then there are heavy reporting requirements for what's being done with the money. I don't know what's going on with these slides here. Let me see. Yeah, no. All right. Well, aligning your business structure with long-term goals. We're going to move past that. Oh, I hate this. Okay. I apologize for whatever happened here with this scaling. But the main things that you want to be sure of here is that, whatever business structure you choose, that it meets with your long-term goals. If you know that you want to take on a lot of investors or you're looking for opportunities to raise capital, you probably don't want to be a partnership. You probably don't want to be a sole proprietorship, right? If you know that you're looking for flexibility and you want to be able to play around with how you're taxed and how others are being taxed and how much capital gains tax you pay, or how much tax that you pay as an individual versus how much tax you pay as a shareholder, or things of that nature. You might want to, look into something that's going to allow for flexible tax options like a corporation, whether that's a S or a C corporation. Do I have any questions at this time? I haven't gotten any questions yet, so feel free to drop my questions in the comments. Oh, I love this. And then the importance, because that's kind of like wrapping up our portion of this conversation. That's about business structure, and that's about, how you want to organize your business. Before I move into the conversation about what it is that you may want to do in regards to other areas of protection, I want to highlight the fact that no matter what type of organization you create, whether it's an LLC or a partnership or a corporation, you want to make sure that you have an operating agreement in place. An operating agreement is something that's going to let you know and let others know what are the rules of your business. How do we bring on new members? How do we remove members? How do we take on investments? How much investment can we take on? How much debt can we take on? Who's allowed to make decisions for taking on debt? Who's allowed to go out and enter into contracts on behalf of the entity, right? All of these things would be covered in either your operating agreement, if you're an LLC or a corporation, or your partnership agreement, if you're running a partnership. What you must know is that in every state, there are default operating agreements, default partnership agreements. And when you don't have an operating agreement in place, or you don't have a partnership agreement in place, and there's a dispute amongst partners or amongst managers or members, the state, when they're dealing with your dispute in court, they are going to apply the state operating agreement to that. I got a question, but they're going to apply the state operating agreement to your situation, right? So that's something that you want to be mindful of. That's exactly what they're going to do. And this is important because, and Jacqueline, I'm going to get to your question in 1 second, but this is important because in a situation where, say, for example, you're in a partnership, but you own 70% of the business and your partner only owns 30, right? If you don't have an operating agreement in place, the state default rule is that you guys are 50-50 owners. The state default rule is also that you share in 50-50 liability, right? But you guys could have an agreement that, in fact, I'm 70% owner and I have 70% liability, and you're 30% owner and you have 30% liability. But because we don't have anything in writing and now we've had a dispute over something that we were liable for, we're going to share and share alike. And sharing and share alike is generally 50-50. Jacqueline, I have an LLC startup. Can you speak on tax for single owners? So one thing that I would say is that in most cases, depending on how much money you're making, one of the best things that you could do as a single owner LLC is elect to be taxed as an S corporation. Because remember what I said, there's a difference between business organizational structure and tax classification, right? So with that, when you structure yourself in a sense to where you're being taxed as an S corporation instead, a lot of times you could save a lot of the money and not pay that double tax or that higher tax rate. Because in that situation, you could find yourself in a situation to where when you're taxed as an S corporation, you don't have to owner draw all of your money. All of your money isn't counted as an owner draw. And you could specify, my business made $100,000, but I only paid myself $50,000. So then as an individual, you would be taxed on that $50,000, and the corporation generally wouldn't even be taxed on the other $50,000 until it's moved or paid out in some way, shape, or form, whether it's paid out in a dividend or it's paid out in an owner draw later on. Then that's when the tax comes into effect for those things. And we're going to move into, I hate this. The importance of trademark and intellectual property protection. So we're going to talk a little bit about trademarks, patents, copyrights, trade secrets, and like the processes behind these things. And then for trademarks, the main thing that you just want to consider when you're thinking about trademark ownership is, do you own your brand, right? Do you own your brand? Trademarks are connected to any brand name, logo, slogan, sound, or color that serves as a source identifier for your goods and services, right? So that could be anything. When you think about iconic marks, you could think about the logo, the Nike swoosh, or the Apple symbol with the bite out of it. When you think about slogans, you could say, just do it. When you think about colors, you could think about Tiffany blue or the doom doom on Law and Order, right? These are all things that make you think of a specific source. Even if you don't know who the producer of this good or service is, when you see it, you think of a very specific thing, right? So you're going to want to make sure that you're taking ownership of these key elements of your brand that others think of when they think of your service or your good. Because if you don't, others could infringe on those rights and pass themselves off as you, sell products or goods under the same name, try to trade on the goodwill that you've built up in your business, in your brand, right? And you don't want that. You don't want to lose any rights that you could potentially have by not protecting yourself, by not taking ownership of these things. You would hate to be in a situation where you've spent hundreds of thousands of dollars building a brand, and then later on to only find out that you don't own it. When I talk to people about trademarks, I always tell people, you wouldn't build a house on land you don't own, right? You wouldn't do that. And I see I have a question. Let's see. Aaliyah Stewart. Hi, Attorney India. When I start my business, say I want to switch from a corporation to an S Corp, what could be the benefits? So, and I'm going to just run us back, Aaliyah, with the difference between business classification and tax, business organization and tax classification, right? So when you start your business as a corporation, you're either a S or a C Corp, but a corporation itself. So a corporation is a corporation, and that's a business organization. A tax classification is either S or C Corp, right? One of the main businesses of going from a C Corp, and I'm gonna just go back a couple slides here. One of the main advantages of moving yourself from being a C Corp, where the standard corporation is taxed separately from its owners, is that in that situation, when you're a C corporation, when that's your tax classification, you could pay double tax, right? Because you're paying tax on the corporation's profits and the corporation's dividends, but then you're also paying tax on any funds or owner draws that you pull. When you're a S corporation, you shouldn't be paying tax 2 times, because the profits and losses are going to pass through to the owner's personal tax returns, right? So in a C Corp situation, you would have 2 tax returns typically, a tax return for the business and a tax return for yourself as an individual. As a S corporation, you should only have 1 tax return, because all of the income that's flowing through the S Corp is flowing through to you as an individual. Does that make sense? Let me know if you have a follow-up question, Aaliyah. Before I go back, do I have any more corporation questions or business entity questions? Going once, going twice. Type faster. No. Okay, thank you. Got it. So one thing that I do want to talk about, one thing that I definitely want to talk about is the trademarks, right? So with the trademark rights, What trademarks do for you is they give you national ownership of your brand name. A LLC, a corporation, none of those things do that for you, right? The trademark specifically gives you that right. It gives you the right to exclude others, the right to tell somebody you can't call yourself ABC Company because I'm ABC Company and I have registered this with the United States Patent and Trademark Office, and it is a registered mark. And for you to do so, you would be causing consumer confusion and you would be infringing upon my rights. That is what trademark protection does for you. It also gives you the power to create licenses and franchises. So say, for example, you've created a business that's unique to you and you don't want to, you want to expand, but you don't want to open and run all of the businesses yourself. A trademark gives you the rights to create franchisees and to create an agreement where others can buy in and pay a fee so that they can operate under your name, right? Trademarks also give you the power. It gives you customs enforceability. It allows you to say, for example, you have a good that you sell and it's a whole bunch of knockoffs of that good coming into the country. It gives you the power to get an order so that customs can help you enforce your rights, to stop crates of fake goods from entering into the country. Gives you the power to have confiscate and destroy orders created, and you can go into stores that are selling goods that are knockoffs or unauthorized versions of yours and take them off the shelves with the police. It gives you a lot of power in that regard, but then it also adds extreme value to your business when you're thinking about selling your business, because what you're telling a potential investor or a potential buyer is that I have made sure that I own this so that when I sell or you invest, you know that we're not going to have to worry about a bunch of copycats popping up all over the place and trying to, trade or infringe on the goodwill that we've created with others. Now, one thing that I want to just distinguish for you guys really quickly is because a lot of times I feel like people are confused between trademarks and copyrights. So as I had previously said, a trademark is any word, logo, sound, or source identifier for a good or service. A copyright is any creative work in a fixed, tangible medium of expression. So copyrights attach to plays. They also can attach to logos because logos can be creative. So your logo could be copywritten and trademarked. Copyrights are good for websites. If your website has a very specific design, specific style, specific layout, things that you've implemented on there, you want to protect it. You want to make sure that nobody comes along and creates a website that's identical to yours. And then copyright protection, of course, is also good in the business space for, if you have like a little jingle or something that goes with your services, like moo annoying, right? That's something that you obviously will want to have copywritten. And then a patent. Denise asked, what's a patent? And a patent is a new invention or discovery. And when they use that term discovery, they're referring to something that maybe already existed, but you have revamped it in a way that it has a new use. It can be used in a new way. You've modified some things. Most patents of today, in today's age, where pretty much there's nothing new under the sun, most of the patents that you'll see in today's environment are developments of pre-existing patents or a combination of several small existing patents. Like, you got to think, at one point the spring had a patent, and a spring is inside of a cylinder that pushes the toilet paper roll in and out, right? All of these things come together so that you can create a new thing, or it has a new use, even if it's not necessarily a new thing. And I am going to slide up. Do I patent? I do not. I do not patent things. And a big part of the reason I don't patent things is because to be able to patent things, you have to take a special bar for that as an attorney. There's the patent bar, and you have to be eligible for the patent bar to take that test and to acquire those rights to be able to practice that type of law. It's a really technical, highly scientific style of law. So they want to make sure that all of the attorneys that are working in that space know exactly what they're doing and know how to do the science behind and the math behind all of the things that go into that. If you're looking to patent something, one thing I will tell you is a lot of times people think that they've created something new or that they found a new discovery, but in fact they haven't. And you would be better served by a trademark. But I do have a patent attorney. His name is Ronald Baker. He's amazing. He's out of Atlanta. He practices nationwide. I will be more than happy to connect you with him so that you can figure out if you are in fact patent eligible. And then I got another comment here, using text from a book block with bloggers. I'm going to read this question out loud, or this example. Using text from a book in a blog post, a blogger includes extensive excerpts from a copyrighted book in their blog post without permission from the author or publisher. Even if the blogger provides proper attribution, using significant portions of copyrighted text without authorization violates the copyright holder's exclusive rights to reproduce and distribute the work. The infringement involves the unauthorized use of someone else's creative work, which can lead to consequences. This is absolutely correct. This is a prime example. You taking large portions of something that has already been copywritten and weaving it into your work, that is copyright infringement. And something that you should be mindful of when you think about copyright infringement is that copyright infringement is in fact a criminal offense as well. So with copyright infringement, there are civil liabilities that can be attached to that, but you could be criminally charged for that. And with copyright law, intentional copying, there's no such thing as like accidental copying for the most part, right? You might think that you've created something from scratch yourself, but intentionally copying something is a criminal offense. Intentionally infringing on someone's copyrights is a criminal offense. The best thing that you could do when you're looking to create your own works is to only use limited amounts of someone else's copyrightable material, to get permission if you're going to use a lot. Any registered copyright, you're going to be able to log into the US Copyrights website, do a search of that work, and then you'll be able to find who owns it, who you should contact for permission. You should reach out to those people and get the proper permissions. Another thing that you should know too is that every time you post this post with this material that you've stolen, every time you sell a single book or a blog post that incorporates this person's work, each one of those acts is a separate count. And that person that you're infringing upon their rights, they're eligible for statutory damages. In the copyright space, a lot of the law is pre-written, predisposed for what a person is entitled to if you violate their rights. And a big part of that is it's really hard to put a dollar value on what somebody's creative work is worth, right? It's really hard to put a dollar value on that. So because it's really hard to put a dollar value on it, the government has went ahead and given like baseline dollar amounts for these acts of infringement, and they can rack up really quickly because every time you share the post, every time you do the thing, you're establishing another act, another one of those being done. Okay, I got a question here. When should someone trademark their brand? Before they do anything else. Before you register your LLC, before you get your domain name, before you sell any goods or products, you want to make sure that you own the brand before you do any of these things, right? You want to make sure that you own the brand and that you're not investing in a brand that you don't own, because it could be a waste of time. God forbid you spent the time, you spent the money developing this brand and somebody else owns it. A story that I tell often is the story of the original Burger King. When people think about Burger King, we all think about like the King guy and the Whopper and the Burger King that we know today, which is headquartered out of Florida. The original Burger King is in Mattoon, Illinois, right? They were in business maybe 10 years before the Burger King that we know of today came to exist. But the Burger King that we know of today registered their trademark. And then they did what we call froze the other Burger King in place. So this Burger King is still, by the grace of God, because the courts could have told them that they just had to shut down because they didn't have the ownership, but they were able to show that they had just enough brand recognition in their region that the court created a zone around where they were already existing and told them, okay, you can continue to operate these businesses in this space, but you can't move beyond this zone of 10 miles, this 10, 20 mile radius. And I'm just throwing a number out there, but you absolutely want to make sure that you've registered your trademark first. When you think about the order of operations for like creating a business identity, creating a brand, creating a business in general, the very first thing that you should do is trademark your brand. And a lot of times people will tell me like, well, I have my LLC. Your LLC does not give you nationwide priority or ownership of your brand. In fact, you could be the 123 corporation in Texas, and somebody else could also be the 123 corporation in Illinois or California. There's nothing stopping everybody from registering the same exact LLC name in different states, right? So when you think about that, what trademark is doing is giving you that true ownership of your brand name or your slogan or your colors, whatever it is that you're using as a source identifier, whatever it is that you have invested into holding yourself out as to the general public, whatever it is that consumers think of when they think of you and your business, you want to make sure that you own that. And that goes beyond your domain, because somebody else could come and register your trademark after you, right? And then they could file an action against you for cyber squatting, and you could be forced to give up the domain, give up the Instagram handle. YouTube would send you a letter saying, hey, we received this form from such and such showing that they're the registered owners of XYZ, so we're going to deactivate your account. That can happen across the board. So that's something that you really want to be mindful of. And I am at the end of my, and I have a question here. How long is the trademark process? Okay, trademark process. Great question. Great question. Great questions. Oh, I'm getting good questions here. Okay. How long is the trademark process? Your trademark process can take anywhere from 12 to 18 months. Okay. And that's from the day that you click submit on the USPTO's website to the day that you actually receive registration. And 12 months is with absolutely no hiccups. 18 months is maybe with having a substantive office action or the USPTO asking you for more information about your mark. It could take longer, like 24 months to as far as 36 months, if you find yourself in a situation where somebody is opposing your registration. So when you're going through the trademark process, there comes a time in that process that's called publication. And in the publication window, that's 30 days where your mark or your potential brand, whatever it is that you're trying to register, is published in the United States Patent and Trademark Office's Gazette. And then all of the current mark holders who should be policing their brand and paying attention to the Gazette, right? All of those people will have the opportunity to say, hey, wait a minute, this can't be allowed. They can't be allowed to register because this is a situation where they're going to create confusion. People are going to think they're me. People are going to mistake their brand for mine, right? So the process could take anywhere from 12 to 18 months. On the shortest end of it, maybe 10 months. But right now, processing times are really slow. It's taken about 7 to 9 months for your application to even be assigned to an examiner. Right? 7 to 9 months for your application to be assigned to an examiner. And then from the application being assigned to an examiner, you're looking at, the rest of that processing time. Okay. And I got Allison here with a really good question. Can a layperson complete the trademark paperwork? Is the paperwork very cumbersome? A layperson can complete the application, right? The success rate of filing an application as a layperson is like maybe 30%. Most people who file applications as lay people find themselves in like 1 to 3 situations. And I'll give you a couple examples in a second. The first thing I want to say really quickly is like, yeah, you could file it yourself, but will your search be as thorough beforehand? will your mark and your application be crafted in a way to avoid any potential oppositions or office actions? Probably not, right? Just because you don't know what you don't know about the ins and outs of the system, you don't know what you don't know about figuring out what classes you actually operate in. 2 horror stories. One horror story that I'll tell you is, I had a client, she filled out an application. She really didn't understand the differences between a 1A application, which is a use-based application, and a 1B application, which is an intent to use application. So when she filed her application, she did it in a way to where she did it as use-based. And for most of her classes, she was actually in a use-based space, right? But for 2 of them, she should have done an intent to use application. As she's maybe a year into the process, she gets contacted by another company, another brand who says, your mark is going to be confusingly similar to ours. We're opposing you, right? When they filed that opposition against her, they knew that they could win immediately and invalidate her and make it to where she lost in the opposition space, because she had filed 2 of the application classes the wrong way. And so much, in fact, that when she was asked to produce a specimen to the United States Patent and Trademark Office, she had like created something like Photoshop this picture of, let's just say, her logo on some frozen food. And she wanted to register in this frozen food class. And she's like, oh, I know I'm going to be selling these things, these frozen items, right, in the future. But she filed it as use-based, and she just created like a sham document that showed her using the item, right? When we got the interrogatories, the questions for discovery from opposing counsel, they were all about that. None of them were about how long she had been using the mark, the classes that she actually operated in, because they knew that all we need to show is that she filed this improperly, and we're going to win this opposition, and she's going to be barred from registering this mark. So that's literally all they asked about, to the point where I just had to advise my client immediately once I seen what she had done, that the best thing that she could do would be to just go ahead and withdraw her application, because fighting them was just going to take her a bunch of time and money. And in the end, she was going to lose for sure, because she was confused when she was doing the use versus intent to use and what type of application she was supposed to be filing. And even though she had classes that she was actually operating in, that she did have actual use for, that mistake was going to make them a winner no matter what, right? That's one little bit of a horror story. 2, I had somebody come to me before, and they had registered in like 12 classes. For those of you who don't know, the United States Patent and Trademark Office breaks trademark rights into 1 through 45 classes. I can give you an example. Class 25 is for clothing. Class 45 is professional services like attorneys. Class 16 for downloadable goods, right? There are all these classes though, 45 of them. And this woman, she registered this application with like 13 classes. And she paid $250 per class, because that's how they charge you. The filing fee is $250 per class. So imagine how much money she paid being registered in so many classes. Well, she received the opposition. The opposition was from somebody who was basically saying she can't operate in the same class as us because the marks are going to be confusingly similar. It was easy for me to help her pass that, right? Because she wasn't operating in that class. So it was easy for me to let them know, hey, we want to modify the application to remove this class, and then that'll take care of the issue that you guys are having, because it's not that you're saying that she can't register and she can't operate. You're saying that she can't register and operate in the same class as us, okay? And she doesn't operate in this class. And she, as a layperson, was mistaken when she filled out this application. She thought that she needed to be registered in class 25 to sell merch. I can tell you that selling merch is a merchandising right that attaches to whatever class you're registered in. So even if you're registered in class 41 for throwing events, you'll still be covered for, selling merch. You don't want to be registered in class 25 as a producer of clothing items, because that's not what you are. You're an events company that wants to sell merch to support or to, bring awareness to your brand for the events that you host, right? That was the first hurdle that we had to overcome. So we got over that hurdle, but then she did this application as all intent to use. So the thing with an intent to use application is you don't have trademark rights until you file your statement of use. So once you've overcome the hurdle of, getting through the application process, and you get your notice of allowance, which is a legal term, you get this notice of allowance saying, hey, if you could show us use, you could be allowed to register, and you have X amount of time to show us this use. She goes through this process. We get the notice of allowance. Once we get the notice of allowance, I'm like, okay, your notice of allowance is here, but you have to be able to show that you operate in all these classes. So I need a specimen, something that's showing how you use this and how you hold yourself out to general consumers, to the general population in these spaces. Well, she didn't have that, and she didn't have that for most of them because she doesn't actually operate in those classes, right? She's like, well, I read something online that said I should register in as many classes as possible. Yeah, as many classes as possible for your actual use or potential peripheral use, right? So in the long run, I actually had to delete like 10 classes from the application. And that was after she had paid $250 for her class. So she had basically lost $2,500 for no reason, in addition to the legal fees and all of the rest of that stuff that she needed to be done. So yeah, so basically it can be done by a layperson, but having a lawyer saves you time and money. And then if I'm hired, I do fight as well. So it really just depends on what package you move forward with. I have a couple different packages. I allow people to go with like package A, which is once I click submit, I'm done with the work. And if you get any documentations from the USPTO asking you questions about the application or anything like that, you can either choose to hire me to answer those things at the a la carte rates for that. Then I have another package that I offer, which includes the response to a non-substantive office action. A non-substantive office action is something that might ask you to, explain your use or provide a new specimen because the specimen that you provided is too pixelated, or show us a different website or something like that. A substantive office action is one where it's like, hey, we believe that you're going to be confusingly similar to XYZ. These are the grounds that we're thinking as reasons for disqualifying you. And in a situation like that, I will have to prepare a formal legal response that includes legal research, drafting, things of that nature to show how your mark is not like theirs and how you two should be able to coexist without any confusion. But these are like really time-consuming documents that can range from anywhere from like 10 to 100 pages, and it can take a lot of time for me as an attorney to work with you to get the things that I need to get them drafted. So there are a couple of different options that you have when it comes to the packages. But what you definitely want to know is that you really just don't know what you don't know in the trademark space. Another thing that you got to think about is you don't want to file. You don't want to keep coming back to an attorney and having to pay the whole fee over and over again to file. So one thing that I like to make sure of is that when we're going through the process together, I'm focused on what you're actually doing right now, but then I'm also looking at your potential zones of expansion, right? If you're a funeral home, you might buy a flower shop, or you might start having flower packages and being a provider of flower goods, right? Or you might get into burial services and things of that nature. So I'll speak to, in my opinion letters, I'll not only speak to what you're currently doing, I'll also speak to what you could be doing just based off the industry that you're in. Any questions? We can't hear you.
Technology, right? I said I want to make sure you put your contact on the screen. I had it scroll. Oh, there it is. Well, listen, I know that, we can't hear the audience, but I'll do it for them. Let's give it up for Attorney India Rios. That was some great, 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 great information. I will say, and I wrote in our comments, thank you. And shout out to Autumn Caldwell, who has been behind the scenes making sure everything is rolling. Yes, Allison said, very nice. Thank you. Aaliyah said, great information. Denise said, thank you so much for your time, attorney. Cherie said, yes, with a lot of S. Yeah, that is a client. So I did want to say this. We didn't discuss this, but are there any specials for dream builders on this webinar today if they want to work with you?
I have been giving I generally charge $350 for the consultations, especially for any form of consultation. But I've been doing this special for the Dream Center and for brunch bunchers, where you can save $100 off that. So the consultation is $250. But then I've also been taking it a step further and allowing you, after that initial consultation and you pay that $250, I've been applying it to any additional services that you hired me for. So it's kind of like you're getting that free hour, that free advice up front, because I've just been later applying it to anything. So if you come for the consultation, you pay the $250 for that, then that $250 would be applied to the trademark application or the contract or business formation.
Well, that sounds good. Listen, I will tell you from personal experience that having this information is so important, laying the foundation for your companies up front. I think I did want to just quickly, if they submit an application now, that protects them, correct?
So submitting an application right now, what it's going to do for you is, one, is going to give you that spot in line to say exactly when, right? But then it won't give you registration, but it does make your claim to it stronger, right? It will give you the power. You really have the power without anything to file a cease and desist or send cease and desist letters to people that might be opposing on your brand. But being able to say in that cease and desist, I filed trademark application number such and such, and it's pending with the United States Patent and Trademark Office, and we are the owners of this brand, or being able to say that I'm in the process of registering this mark and I've been using it for X number of years and I'm demanding that you stop. It does give you more power there. In the meantime, a little free gem that I like to drop on everybody is that you want to make sure that you're using the little T with the little M next to anything that you're claiming trademark rights in. That's giving you common law trademark rights. That's letting everybody know that I am claiming that I own this as a trademark. And then once you've obtained your registration, you're going to turn that little T with the M into the R with the circle.
All right. Listen, this is amazing. I have 2 real life examples of trademark infringement against me. And I accidentally, I guess, infringed on someone else's. And so for those of you who know, I created an app for the Dream Center called Alfred. And although I knew it was a common name, and there were some other apps with the name, I'm like, whatever, they won't find me. But within 30 days, I got a cease and desist letter from one of the app's attorneys saying that I needed to change my name and remove it from the App Store before they did litigation. And of course, you don't want that smoke. So as Attorney India has taught me, and we're teaching our members, is, if you stay ready, you don't have to get ready. So, you'll spend more money fighting claims and trying to keep a name and rebranding than you will just paying to get the trademark. So once again, thank you, Attorney India. Listen, this was an amazing webinar. This was the kickoff to our 21-day business reset challenge. I don't care if you've been in business for 1 day, 1 hour, 1 year, 10 years, 100 years. Trust me, it's going to be beneficial to everyone. While we were on this webinar, I got a text, and please bear with me. This technology, and I've been moving fast, and people have had issues signing up from every turn. So the $99 was ending this evening, but we're going to extend it until tomorrow because I just had to go on our link tree and fix the link while I was on here. But if you're interested, go to thedreamcenter.com. There it is going across. Look, technology works when I know how to work it. But we're excited. Listen, Attorney India is going to be giving us some templates to share with our participants, contract templates. She has a great template package. We're not going to give them all away in the challenge, but we're going to give you a few. We want to make sure you're prepared. Make sure that you share with everybody that is happening here at the Dream Center. We appreciate you for joining us tonight, Attorney India. We're going to let you go. I was about to say believers. Facebook, Instagram, Dream Builders Collective, YouTube. Thank you for joining us on the Dream Builders Podcast webinar series. We'll be back here for all registrants of the challenge next Thursday. It'll be a private stream, but we'll be talking to two very good tax accountants to make sure that we got our money right. So until then, go to thedreamcenter.com, sign up for the 21-day challenge, and I will see you all on Monday. We're going to make sure that we are rocking and rolling and prepare for all that's coming our way. All right. I will see you all on the flip side. Thank you again for tuning in to the Dream Builders Podcast.
When you're a small business owner, you need access to the tools and support you never knew you needed. At the Dream Center, we offer co-working space and support services that elevate the everyday entrepreneur. Centrally located in the rising Soul City corridor of Chicago, we're the ideal environment, offering monthly and quarterly networking for members. Bring your idea to fruition. Expand to new heights. Call now or visit thedreamcenter.co today.